Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about trial delays and complex cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Andrew Nugent and his company were prosecuted in a case involving the death of an individual who was poisoned by cyanide at his workplace. There was a toxic gas that he breathed in, and it ultimately led to his death. The case involved very complex issues, both in dealing with the personal liability of potential parties involved in the decision-making at the company, as well as in dealing with the corporate liability for the company. And there were multiple trials going on in court at the same time. For one of the trials, which was the last one to be resolved, it was ultimately set for trial 3 months after the presumptive sealing from the Jordan decision was expired. An application for the charges to be stayed on the basis of unreasonable delay was brought and dismissed, ultimately by the Court of Appeal. Leave was sought by the Supreme Court of Canada and dismissed. This case raises important issues when it comes to questions of what happens in the context of complex litigation. There's an exception to the 18-month sealing in Jordan that if a case is unduly complex or has a lot of different moving parts, that the complexity of the case can excuse the Crown from bringing the case to trial and completing the trial within the 18-month timeline. But the question becomes, is the 18-month timeline meant to be a guideline only in non-complex cases? This was the issue that Mr. Nugent was trying to have addressed by the Supreme Court of Canada. He was also concerned about the Crown's position, which was that the ongoing negotiations and resolution discussions with Crown dragged out the process, and that those shouldn't count towards the presumptive sealing. These are also important issues. The whole point behind Jordan was, one of the things was to encourage counsel to spend more time coming to thoughtful resolutions of matters and decide which matters truly need to be brought to trial. But if all of that time where that's happening doesn't actually count, then isn't the presumptive sealing just really lifeless? And doesn't it not have any force, especially when you have a complex case where those discussions are going to take longer than an ordinary case? And if the complex case always takes it out of the circumstances of Jordan, as opposed to may take it out of the circumstances of Jordan, as the argument was in this case, then do the circumstances of Jordan really only apply to the everyday litigation cases, simple thefts, impaired driving, and the types of cases that don't pose the highest stakes for individuals, like cases involving criminal negligence charges leading to somebody's death? Those are important issues that the Supreme Court of Canada ought to have determined, and unfortunately they weren't addressed by the court in this case, which means that we still have a ton of unanswered questions about the application of the Jordan decision and the 18-month sealing, and that necessarily is just going to lead to more litigation in this area as people try and determine what it means in each individual case. The Jordan decision threw a wrench in criminal law in Canada, and the Supreme Court of Canada owes it to people to clarify what they meant and how these things are to be applied when they're sought to speak upon it in a leave application. Unfortunately, it's going to take another case and countless other cases involving this type of litigation before the Supreme Court of Canada gives us the much-needed clarity about how all of what they said in Jordan is meant to be applied. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull for putting together these videos. Please like, subscribe, and share with your friends.